Good morning, everyone. Welcome to our 2019 Federalist Society Annual Western Chapters Conference here at the Ronald Reagan Presidential Library. My name is Lisa Ezel. I'm the Federalist Society's Vice President of our Lawyers Chapters. This is our 13th year of hosting this conference at the library, and it grows larger every year. In fact, this is the first time we've sold out, so thank you so much for being here and joining us. On the behalf of our Lawyers Chapter leadership, I'd like to welcome everyone here today for our conference, which features discussions on local control, nationwide injunctions, and labor and employment issues post-Janus. At lunch, we're going to hear from former White House counsel Don McGahn, and we'll conclude today with some time to tour the library and a closing reception at the Air Force One Pavilion, and I hope all of you join us for that as well. Whether this is your first time at this conference or even at a Federalist Society event at all, or if you're a veteran of most of these 13 conferences, we hope you find the ideas discussed today very thoughtful and engaging. I also hope you enjoy the fellowship here amongst the other attendees. And I'd also like to make a pitch for getting involved with our Lawyers Division and our Lawyers Chapters and student chapters here in California. I know we have leaders, I think we have our chapter presidents from all of our California chapters, as well as leaders from chapters in Arizona, Colorado, Nevada, and a few other in Oregon. So they're all identified as a chapter leader on their name tags, so please introduce yourself, and we'd welcome your involvement with these groups. So with that, I'd like to introduce our first moderator, Judge Allison Ide. Judge Ide serves on the U.S. Court of Appeals for the 10th Circuit. She was nominated by President Trump in June 2017 and confirmed in November of 2017. Judge Ide is a graduate of Stanford University and the University of Chicago Law School. She then clerked for Judge Jerry Smith and Justice Clarence Thomas. Judge Ide practiced at Arnold & Porter, taught at the University of Colorado School of Law, and served as Solicitor General of Colorado. She was then appointed to the Colorado Supreme Court, where she served from 2006 to 2017. We are delighted to have her join us here today, and with that, I will turn things over to Judge Ide. Thank you.
Well, thank you for that kind introduction. I just want to start by thanking the Federalist Society for inviting me here today. What she didn't say is that I actually worked in the Reagan administration, and that dates me. That was my very first job out of college. I worked for Bill Bennett at the Department of Education. So it's just really a privilege to be here today in this beautiful spot, in this beautiful weather, and I'm amazed you're all here inside, but I appreciate you being here. We have a terrific panel for you today, and it's really a privilege for me to introduce our panel members, and then I'll tell you briefly about how we're going to go about our panel. First, we have Professor Michael Morley. Even though he's sitting in the middle, he's going to go first. He joined the faculty of Florida State in 2018. He's basically written on everything, but of particular interest today is his work in nationwide injunctions. Prior to that, he clerked on the 11th Circuit for Judge Chafee. He was an associate at Winston & Strawn, and he was also special assistant to Army General Counsel. He's a graduate of Princeton and Yale Law School, and he's going to kick it off today to give us kind of a theoretical framework about different kinds of injunctions and really orient us, I think, in this area. Next, we're going to have Scott Keller. Mr. Keller is the chair of the Baker-Botts Supreme Court practice, and he's argued 11 cases before the court and briefed many, many more. Before that, he served as a law clerk for Judge Kaczynski on the 9th Circuit. He was a Bristow Fellow, and he clerked for Justice Kennedy. Additionally, he served as Solicitor General of Texas and as Senator Ted Cruz's chief counsel on the Senate Judiciary Committee. He's a graduate of Purdue, so I found out earlier he has Midwestern roots and roots for Green Bay. Okay.
Go.
Take that for what you will. He attended the University of Texas Law School, and he will talk about his experience mostly in the Solicitor General's office about his experience with nationwide injunctions. Finally, we have Jordan Smith. Mr. Smith is currently of counsel at the Las Vegas firm of Pisanelli Bice. He previously was Deputy Solicitor General of Nevada, where he worked on nationwide injunctions regarding overtime regulation, and that will be the subject of his remarks today. He was named Appellate Lawyer of the Year, amongst other awards, and he is a graduate of the University of Iowa and Drake University Law School. Each panelist will give their opening remarks for 10 or 15 minutes. Then we will have some time for back and forth amongst the panelists, and then we will open it up for questions from the audience. So, Professor Morley.
Thank you very much, Judge Ide, and I'd like to thank you all very much for coming here. It's an honor to have the opportunity to present, particularly here at the Reagan Library. I want to begin by emphasizing that the topic of nationwide injunctions is a thoroughly nonpartisan issue. Most of the recent debates over nationwide injunctions have hinged on court orders completely blocking enforcement of particularly President Trump's initiatives, executive orders, other types of Republican-supported measures. But it was only a few short years ago when some of the first nationwide injunctions in modern history were handed down, toward the end of the Obama administration, where it was primarily Democratic-backed policies, such as DACA, the Department of Education's policy with regard to transgender student bathroom usage, that were being subject to these orders. So in determining the judiciary's proper approach to nationwide injunctions, it's important to recognize at some point or another, it is overwhelmingly likely that a policy that you support might be on the wrong end of one of these. And so, particularly because both parties stand to lose from them, we have the opportunity to assess this controversial issue from an objective, nonpartisan perspective. I'd also like to suggest that part of the reason there is so much confusion over nationwide injunctions stems from two main factors, and both of them deal with language. The first is that we take often an analogy or a metaphor too literally. This notion of courts striking down laws as unconstitutional, right? This is language we use all the time. We colloquially speak of this. But when Judge Ide holds a law unconstitutional, she's not there in her chambers ripping it out of the U.S. Code and throwing it into a fireplace.
No, you know
well, I mean, maybe she is, but we don't know what goes on. But at least that is not literally what we're referring to in talking about courts striking down laws. Go back to Marbury v. Madison, where the Supreme Court explains the process of constitutional judicial review. Marbury tells us the power of judicial review is simply the power to lay a federal statute against the Constitution, and it becomes essentially a choice of law issue, right? I mean, nobody likes Erie, but it's basically an Erie-type question, right? It's a choice of law question. If you have a state law, if you have a federal law that conflicts with a constitutional provision, if you cannot enforce both, if the state law conflicts with if the federal or state law, for that matter, conflicts with the Constitution, which do you follow? And so judicial review is the process of choosing to follow the Constitution rather than the federal law, refusing to give the federal law legal effect in the context of that particular case. Looking at judicial review from that perspective leads to a very different conception of whether judges should be going around attempting to completely nullify and invalidate statutes far beyond the boundaries of the case before them. The other main source of confusion I'd like to suggest that arises with regard to nationwide injunctions is the term nationwide injunction itself. It is the most misleading term you could possibly use, in part because it's not an it, it's a they. The phrase nationwide injunctions has been used and can be used to refer to 4 different types of court orders. Each of these court orders implicates different constitutional, statutory, rule-based, prudential, fairness-related considerations, and each of them needs to be treated differently. And so by using the blanket umbrella term nationwide injunction to refer to each of these four categories of orders, I would suggest contributes to the confusion. So what I'd like to do here today is introduce the concept of nationwide injunctions by unpacking it, by explaining and distinguishing among the four types of orders that have been called or could reasonably be considered nationwide injunctions, and explain which are good and which aren't. So to begin, what we might refer to as a plaintiff-oriented injunction, a nationwide plaintiff-oriented injunction. This is perhaps the quintessential hallmark of equity. It is an order issued in a particular case, tailored to enforcing the rights of the particular plaintiff before the court, hence the name plaintiff-oriented injunction. It is completely unremarkable to note that a federal court's order protecting a plaintiff's rights may have nationwide scope. And so in some sense, the concept of a nationwide injunction, the concept of a single judge's order having national applicability is unremarkable. The three main considerations that dictate whether a nationwide plaintiff-oriented injunction, an order tailored to enforcing the rights of a plaintiff before the court, are valid arise from what I refer to as the legality constraint, the standing constraint, and the threat constraint. Most basically, the first question is the conduct actually illegal everywhere in the nation? With regard to a federal statute, the answer is simple. With regard to state laws, you particularly see this in unfair competition cases. Sometimes plaintiffs will seek nationwide injunctions preventing defendants from engaging in certain conduct that they contend it constitutes unfair competition. And it turns out that state laws differ, that under the law of some states, the competition actually is illegal. In other states, the challenged activities are legal. And so in that type of a situation, a nationwide injunction would be inappropriate, simply because the conduct isn't illegal everywhere. The second main limitation on the geographic scope of a plaintiff-oriented injunction, the standing constraint, is simply, does the plaintiff have standing to seek a nationwide injunction? Does the plaintiff face a reasonable imminent risk of harm in Maine and Alaska and California and Florida? If many times we see plaintiffs going into court asking for nationwide plaintiff-oriented injunctions, trying to stop the defendant from engaging in challenged conduct anywhere, but the only place the plaintiff engages in business is a handful of states, and the only place the plaintiff is even reasonably, foreseeably going to engage in business is a handful of states. And so Article 3, as well as traditional equitable principles, would counsel a nationwide injunction would be inappropriate there. The injunction needs to be tailored to enforcing the plaintiff's rights, and so limited to areas where the plaintiff has standing to assert a claim of harm. And then finally, the inverse of this, the threat constraint, we look to where is the defendant engaged in activities? Where is the defendant reasonably likely to engage in activities? If it is merely speculative, if it is merely hypothetical that the defendant is going to engage in conduct on a nationwide basis, if the defendant's activities tend to be confined or are confined to a particular geographic region, then again, it would be inappropriate to issue a nationwide order. But all of these considerations of legality, standing, threat, all are focused on what is necessary to enforce the plaintiff's rights. The second type of nationwide injunction is what I refer to as the defendant-oriented injunction. And this is perhaps the most controversial type of order, what most of us typically think about when we think about the concept of nationwide injunctions. A defendant-oriented injunction, rather than being focused on the rights of the plaintiff in a non-class case, in a non-class action, instead say to the defendant, you government agency, you government official, may not enforce this challenged policy, regulation, statute against anyone, anywhere in the nation. And so rather than being focused on enforcing the rights of the particular plaintiff before the court, which again is the hallmark of traditional equitable principles, certainly is the hallmark of an Article 3 case or controversy, a defendant-oriented injunction goes far beyond enforcing the rights of the plaintiffs before the court and instead focuses on the defendant, saying you cannot enforce this challenged legal provision against anyone, anywhere, including third-party non-litigants who are not before the court. Nationwide defendant-oriented injunctions are improper from virtually every conceivable perspective. Most basically, plaintiffs before the court do not have standing under Article 3 to assert the rights of third-party non-litigants who are not before the court. Conversely, it is beyond the scope of the case or controversy in front of the court for the court to go beyond vindicating the plaintiff's rights and to impose an order that unnecessarily goes beyond those rights to third-party non-litigants. If you think back to the Lujan conception of standing in terms of injury in fact, causation, and redressability, the main reason why nationwide defendant-oriented injunctions are beyond the scope of Article 3 is because they do not redress the injury in fact that the plaintiff has suffered. And the Supreme Court has constantly told us, going back to City of Los Angeles versus Lyons, that standing is not distributed in gross. Rather, the plaintiff has to show Article 3 standing for every type of relief that they seek, and the plaintiff simply lacks standing to seek relief on behalf of third-party non-litigants. There are also due process concerns of allowing a court to purportedly adjudicate the rights of third parties who received no notice of the proceeding, who didn't have an opportunity to be heard in the proceeding, who might not even be within the court's personal jurisdiction. There's also fairness concerns, what I term asymmetric preclusion. If courts are able to give nationwide defendant-oriented injunctions, this means that if the government wins, if a court says this statute is constitutional, another right holder can go into court, and in fact, in most jurisdictions, district court rulings don't even have stare decisis effect. So another right holder could conceivably even go into the very same court, bring the very same claim, and would not be precluded by that first ruling. No matter how many times the government wins, such rulings would not bind, would not preclude other right holders. And even if the government were to win at the circuit level, where at least the ruling would have stare decisis effect within that circuit, such a victory would not preclude right holders in other circuits from continuing to pursue their claims. But now, what if the plaintiff wins? If courts can give nationwide defendant-oriented injunctions, then if any plaintiff wins anywhere in the nation, then all right holders stand to benefit. So whereas the government gets no preclusion, no matter how many times it wins, a single victory by any plaintiff in any court could dispositively settle the issue across the entire country. There are also rule-based concerns under Rule 23. We have a mechanism, we have a vehicle under current law for allowing right holders to bring similarly situated non-parties before the court to, in a sense, make them parties to the litigation under Rule 23b2, which is specifically tailored to address injunctive relief. So allowing courts to grant effectively class-wide relief in non-class cases without meeting the requirements of Rule 23, without going through the procedures of Rule 23, without implicating the preclusive effects that result from Rule 23 class certification, effectively nullifies the rule. And finally, I'd suggest that nationwide defendant-oriented injunctions conflict with the structure of the federal judiciary. Going back to the Everts Act of 1891, Congress has deliberately structured the judiciary in a hierarchical, decentralized fashion where, with exceptions such as the U.S. Court of Appeals for the Federal Circuit, in general, most federal judges have limited jurisdiction, their rulings have limited stare decisis effect, allowing courts to issue nationwide defendant-oriented injunctions allows a single judge, and potentially even a single circuit, to give their rulings the force of law throughout the nation, to adjudicate and enforce the rights of right holders throughout the nation, even though their rulings lack the force of law in those other jurisdictions. The third type of order, a plaintiff class injunction. If a court certifies a nationwide class of right holders, then, under traditional equitable principles, class-wide relief ruling in favor of all right holders would be the appropriate response. I would suggest the main concern with nationwide plaintiff class injunctions isn't the scope of the order, but rather the scope of the class. Particularly in constitutional challenges, district courts should certify classes on a district-wide or circuit-wide basis rather than a class-wide basis. And one of the main reasons for this goes back to a case called United States versus Mendoza, where the Supreme Court held the government is not subject to offensive non-mutual collateral estoppel, which is a mouthful that basically means just because one person prevails on a legal issue against the government doesn't preclude the government from relitigating that same issue in other courts against other right holders. And so the whole reason the court rejected the application of offensive collateral estoppel against the government was to promote relitigation, was to promote percolation, was to ensure that a single plaintiff in a hand-picked case with the most favorable facts to them, potentially before a forum-shopped judge, cannot set the law for the entire nation and force the Supreme Court to hear the issue in that particular context. I'm running out of time, so I'll just briefly touch on the fourth type of nationwide injunction. We could talk about it in the Q&A if you're interested, and that is the concept of an associational or organizational injunction, where a group, an entity, goes into court and seeks effectively nationwide relief, saying that either it or its members require such relief. And I would suggest that litigants should not be permitted to exceed Article III's limits through the use of associational or organizational standing. So by thinking about these types of categories and by focusing on the distinctions among various types of nationwide injunctions, we can determine when such orders with national applicability are valid and when either the law, the Constitution, fairness, the rules, the federal rules themselves preclude such relief. Thank you very much.
All right, Mr. Keller.
Thank you very much, and it's a pleasure to be with you out here in California. And I want to thank the Federalist Society. It's such an important organization for putting on events like this and looking at a legal issue from all sides and inviting speakers to take positions from all different political stripes and spectrums. And I just have to say that only the Federalist Society could get a group of over 300 people to come out on a beautiful California Saturday morning at 9 a.m. and talk about nationwide injunctions. But here we are. This may be the most that equitable power of courts have ever been discussed on a Saturday morning, particularly in California. But here we are, and I'm thrilled to be with you. I'm going to talk about three things, and piggybacking off of what the professor said. First, I want to talk a little bit about how did we get here? How did the Supreme Court precedent get to this place? The second thing I want to talk about is the Texas experience, particularly in the Obama era. And the third thing I'll talk about is where are we, where's the Supreme Court going, what do nationwide injunctions, what will they look like going forward? So the first aspect of this debate, I think, has to start with the history. And I'm not going to get into a lot of the history from over 100, 200 years ago, but I will say the Supreme Court in a couple different areas in the last, say, 50 to 70 years has kind of set the stage for where we are today. And one of the big things the Supreme Court did was it said there is such a thing as a facial challenge. Well, what's a facial challenge? Facial challenge is a lawsuit and a case that when you go to court, if you prove that, here we're talking about federal policies, a federal statute or a federal administrative regulation or policy is invalid, and it would be invalid in all circumstances that it could be applied to any litigant, then what the Supreme Court has said is that can be invalidated in full. Now, the Supreme Court, I believe, was talking about itself doing that. But I think what's happened is lower courts, rightfully so, have seized on the fact that there is, first of all, such a thing recognized as a facial challenge. And so if you're a district judge or you're a circuit court, and you have before it yourself an argument from a litigant that says, this policy is unlawful, and the argument we're making means it would be unlawful as applied to anyone, anywhere. Well, picking up on what the Supreme Court had did, lower courts, I think naturally following Supreme Court precedent, had said, well, yeah, that's a facial challenge, it succeeds, it's invalid in all circumstances. And the natural consequence of that for a number of years was then an injunction saying that that policy is in fact unlawful in all circumstances. Now, in more modern times, the debate has arisen whether that practice that had been going on for some time is valid. But a second aspect of that, and I think maybe one of the reasons why the legal community became dulled to the prospect of those nationwide or facial injunctions, is because, particularly in administrative law, there are a subset of important cases that can only be raised through the D.C. Circuit. And when the D.C. Circuit would say that a particular federal administrative policy was unlawful, that was the only court where that issue could be raised. And so, very similar to the Supreme Court hearing a case, when the D.C. Circuit heard that case, that would also have at least national implications. And there wasn't this problem about, well, other courts wouldn't be able to weigh in on the issue because it had been assigned to that. Now, related to that, in the administrative law context, there is also the text of the Administrative Procedure Act, which says that when a court finds a policy or an administrative regulation unlawful, it shall set aside that administrative policy. Now, there's a debate right now between, well, does set aside mean that you actually do get to issue a nationwide injunction because maybe you're not ripping a page out of the books and throwing it in the fire, but you're doing something of the equivalent of that in setting the entire policy aside instead of worrying about who's the particular plaintiff or defendant in front of you. So I would say that's kind of the groundwork. That's where a lot of the debates that we're having today started from. And for some time, those weren't thought to be controversial, but I think now people are starting to see that, well, when you carry those to their logical consequences, they have profound effects on the judicial system and how it interacts with administrative policies. So from that, I'll turn to Texas's experience in the Obama era. The state of Texas brought tens of lawsuits challenging federal administrative regulations and sub-regulatory policies during those years. And that was done under both Attorney General Greg Abbott and Attorney General Ken Paxton. Many of those lawsuits were not seeking nationwide injunctions. They weren't. But some of them were. And I think the most notable one was the state of Texas's challenge to the Doppel, the immigration policy that would have granted over 4,000 million unauthorized aliens lawful presence, Social Security benefits, retirement benefits, et cetera, work authorization. Now, the argument that we raised in that lawsuit was we need a nationwide injunction for a few reasons. First of all, we had 26 state plaintiffs. Now, it's not 50, but over half the states, that's a substantial amount of coverage of the country. And the second and the most important reason why a nationwide injunction would have been proper in that case was because the very nature of our challenge was that the federal government could not say that a certain number or certain individuals were lawfully present in the country. I don't know how a court could possibly craft a remedy that would say, okay, you can't be lawfully present in Texas, or you can't be lawfully present in these 26 states, but you can be lawfully present in all those other states out there. A practical problem, of course, is because obviously in this country, the Supreme Court has recognized a right to travel. We don't have border checkpoints at states. We don't have states with borders. There's a free movement of individuals. And so if you can come into California lawfully, well, then you can easily move to Texas. You can move to other states. And so practically speaking, I'm not sure there would be any way to tailor an injunction in that particular consequence when we're talking about immigration and someone who's lawfully in the country or not lawfully in the country. And then, of course, we have the text of the Constitution that refers to a uniform rule of naturalization. And we have congressional statutes saying we need a uniform immigration policy. And those were the reasons adopted by the district court in the Fifth Circuit in the Doppel litigation as to why a nationwide injunction was proper in that context. But the courts did not say in that case, I'll repeat, they did not say that every time you have a facial challenge to administrative policy that's successful, or every time you're challenging an administrative policy, that you get a nationwide injunction. And I flag that just because now turning to the more modern use of nationwide injunctions in the Trump era, it was striking, and we were fairly surprised in Texas when all of these blue states were bringing lawsuits in all sorts of areas saying that they should all get nationwide injunctions every time they were challenging a Trump policy, citing our Doppel case about lawful presence in immigration. Now, I can understand why they are citing that case, because it is an example, is a very prominent example of a nationwide injunction. But the more courts get away from tailoring remedies to the plaintiffs, and again, I submit that Texas and the 26 state plaintiffs there needed a nationwide injunction to remedy that situation because of the practical problems of not having a uniform immigration policy and having state-by-state differences on who's lawfully present, who can work, who's getting benefits. But that's very different when you start to talk about, for instance, when the city of Chicago sues the federal government saying it should get grant money even though it's a sanctuary city, contrary to the Trump administration policy. And then a district court says, yeah, city of Chicago, you're correct. But not only are you correct, I issue a nationwide injunction blocking the federal government from implementing this policy withholding funds anywhere in the country. Now, I'll tell you, in Texas, that was also particularly startling because in the state of Texas, the Texas legislature passed a law forbidding cities from being sanctuary cities. So that is a very blatant example where that injunction by no means needed to cover the state of Texas whatsoever, and that district court didn't even engage in that type of analysis. Now, the Seventh Circuit did stay the nationwide injunction aspect of it. And turning now to where we are seeing the courts having a dialogue, I think, amongst themselves and trying to figure out on a case-by-case basis, when is a nationwide injunction proper? When is it not? I think part of the reason you've seen the U.S. Solicitor General's office file so many petitions for mandamus, petitions for certiorari before judgment at the U.S. Supreme Court at an unprecedented rate is because they're facing an unprecedented amount of litigation about nationwide injunctions and policy changes. And the Solicitor General, Noel Francisco, has been doing a terrific job of highlighting these issues and pressing these cases when they need to be pressed. Because to take a step back, what we're talking about here, I believe, is truly an unprecedented attempted use at nationwide injunctions. And again, I admit, in Texas, we filed for nationwide injunctions occasionally in big policies that would have had sweeping effects for the plaintiffs when we needed those types of remedies. But what we've seen from blue states, first of all, I'll point out, in the very first year of the Trump administration, blue states were bringing lawsuits challenging Trump administrative policies at an 8x, an 8 times rate compared to what red states were bringing lawsuits from the Trump in the Obama era. And so the fact that they're bringing so many lawsuits and they're asking for nationwide injunctions in virtually all these cases means, of course, courts are going to have more opportunities to issue these injunctions. And of course, they're going to have to be forced with looking at when are these proper. And these are now bubbling up to the appellate courts. And I think soon the U.S. Supreme Court is going to have to take one of these cases, whether it's the Chicago case, there are a few other cases. The Supreme Court in the travel ban case issued a large but partial stay ahead of time in that nationwide injunction. So this issue is not going away anytime soon, but I do believe the Supreme Court is on the cusp of taking a case to provide clarity as to what and when nationwide injunctions are proper. I'm willing to bet you're going to walk away from this panel probably even more confused about when is it proper and when isn't it proper. I think, unfortunately, the answer is probably going to be something along the lines of the traditional test for when you should have injunctive relief, and that is the injunction should be tailored to protecting the plaintiff, but also giving the plaintiff complete relief. And in times, those goals can sometimes be in tension. As I mentioned in the Texas Doppel case, I think to give those states complete relief, it was a nationwide injunction was required there. But just because that was the case in one major prominent case challenging a big Obama-era policy, that by no means dictates that every time a state sues the Trump administration, they should be getting a nationwide injunction. Thanks.
All right, Jordan Smith.
First, I would also like to thank the Federalist Society for inviting me to participate, Lisa Izell in particular for her help. This is a wonderful conference, and like all Federalist Society events, really demonstrates why the Society is the nation's premier legal organization. So thank you for having me. In my remarks, I'd like to focus on really 3 points. The first is a historical point about the equitable foundation for universal injunctions, and unfortunately, it'll probably involve some of the history Scott spared us from. The second point assumes then that nationwide or universal injunctions are consistent with Article 3, and if so, what can courts do then to enforce those universal injunctions? And the third point will address some of Professor Morley's comments and the scholarship that addresses the intersection between universal injunctions, class actions, and class certification. On the first historical point, Justice Thomas recently wrote separately in Trump versus Hawaii, expressing doubt about whether universal injunctions are consistent with traditional historical principles of equity. However, I think there is a historical analog, a historical foundation, a basis in equity for universal injunctions in the form of bills of peace. A bill of peace was a device in England, English courts of Chancery, to avoid a multiplicity of lawsuits. The avoidance of the multiplicity of lawsuits was itself a separate jurisdictional hook, if you will, to get into an English equitable court. And I don't mean to inject any more uncertainty with regarding terms. The parties already kind of quibble about whether we call them nationwide injunctions, universal injunctions. Professor Morley prefers defendant-oriented injunctions. Justice Gorsuch referred to them as as cosmic injunctions at a recent oral argument. So there's already a bit of a confusion about the terms we should use. But there's a very helpful 1932 Harvard Law Review article by Zachariah Chafee, which examined bills of peace in multiple parties. And he sort of explained bills of peace as working like this. On one hand, you have one party or entity referred to as the adversary, and on the other hand, you'd have several persons or entities referred to as the multitude. And you could have the adversary bring a bill of peace against the multitude. The classic example would be you'd have an English lord bringing a bill of peace against his tenants. Or on the other hand, you could have members of the multitude bring a bill of peace against the adversary on behalf of other members of the multitude. So keeping with the same example, you'd have some tenants bring a bill of peace against the lord on behalf of all remaining tenants. In more modern terms, you would think of it as the federal government being the adversary, and then whoever's requesting the universal injunction as being a member of the multitude. And in those cases, it was well accepted that the decree granted by the equitable court, the English Court of Chancery, would provide relief beyond the parties to the case. The relief would extend not just to the tenants that sued the lord, but also all other similarly situated tenants. And that practice continued on in America after the founding. The most obvious example and most prevalent example would be you'd have some taxpayers bringing a bill of peace challenging municipal or county ordinance or tax, and sometimes courts would enjoin the ordinance or tax, not just on behalf of the taxpayer that sued, but also on behalf of all their taxpayers. There are other examples of that. Professor Samuel Bray, in his phenomenal article, Multiple Chancellors, identified Hammer versus Dagon, Hart, a 1918 case where the court there granted an injunction that extended beyond the parties. In that case, a father and two sons challenged a labor regulation, and the district court granted an injunction not just to the three plaintiffs, but an injunction that extended to the entire Western District of North Carolina. So while that injunction was geographically bounded, it did extend beyond solely the parties to the case. The traditional sort of narrative is that the first modern universal or nationwide injunction was entered in 1963 in Wirtz versus Baldar Electric. However, I think if you look at some of the cases from the 1930s and 1940s, there are other examples of injunctions entered that would qualify as universal. For example, I'd point you all to Perkins v. Lukens Steel. It's a 1940 case by the District of Columbia, actually cited in Wirtz. And there, the Court of Appeals for the District of Columbia granted or affirmed a universal injunction on behalf of the entire iron and steel industry. The Supreme Court eventually reversed that for lack of injury, not just to non-parties, but also to the 7 companies that brought suit. But it's an example about how the DC Circuit in 1940 didn't think that a universal injunction extending to the entire nation was beyond its powers. And so the question to me then isn't necessarily whether courts have power under Article 3 to grant injunctive or equitable relief that extends beyond the parties outside of the class action context or to issue a universal injunction. I think quite clearly that they do. The history of bills of peace demonstrate that. Early American courts and these early taxpayer decisions and Perkins v. Lucan Steel demonstrates that, as well as other standing doctrines. For example, associational standing, third-party standing allows a plaintiff to assert the rights of others even if they themselves do not have injury. So while standing is required to get into federal court, I don't think it necessarily dictates the scope of the remedy. Justice Thomas himself, in his separate opinion in Trump versus Hawaii, recognized bills of peace as an exception to the general rule that courts only grant relief to the parties. And I agree with that. I think universal injunctions should be the rare exception. But the fact that the exception even exists demonstrates that it doesn't offend Article 3 to issue a universal injunction. So I think the focus of the debate really should be then on what are the limits to universal injunctions and when are they properly entered. I know lots of scholars have put forth their own tests. I think I read a student note that had like 13 factors in addition to sub-factors. I wouldn't want to have to be the one to write that brief. But if bills of peace are the historical foundation for universal injunctions, I think more work needs to be done examining what are the limits or what were the limits on bills of peace and translating them into the modern day universal injunction practice. And my second point then assumes that universal injunctions are appropriate under Article 3, and the question will inevitably arise, what can courts do to enforce those injunctions? And that's an issue that popped up when I was in the Nevada Solicitor General's office in our 2016 litigation against the Department of Labor's new overtime regulation. Just to give you some quick background on that case, Nevada led a coalition of 21 states, including Texas, and obtained a nationwide injunction enjoining the department from implementing and enforcing a new overtime regulation that would have more than doubled the salary threshold under which certain salaried employees would have been entitled to overtime. The injunction in that case clearly prohibited, and it was a pre-enforcement challenge, pre-effective date challenge, and that order clearly prohibited the department from implementing and enforcing the regulation. Effectively, the regulation never came into being, never got off the ground. In any event, an employee of Chipotle in New Jersey took the position that many people take with regard to universal injunctions, that the Nevada decree only bound the parties. In other words, she was arguing that the injunction only prevented the rule from going into effect with regard to the states vis-a-vis the Department of Labor. In her opinion then, the rule went into effect for everybody else, and Chipotle, unbeknownst to everybody else, Chipotle should have been paying her overtime. Chipotle then, instead of fighting that out in front of the New Jersey judge, who was likely forum shopped as well, they moved for contempt of the nationwide injunction in our underlying litigation in the Eastern District of Texas. So this episode presents sort of the opposite side of the coin from the usual universal injunction controversy. We're normally debating whether a universal injunction can provide relief to non-parties who they themselves are potential plaintiffs and could bring their own suits. Instead, this involves the issue of can a universal injunction be enforced against non-parties? And Judge Mazant from the Eastern District of Texas said yes. He held the employee of Chipotle and her lawyers in contempt of the nationwide injunction for filing the New Jersey lawsuit. And to keep it with my historical theme, there is a historical basis in equity to hold non-parties in contempt of an injunction. The seminal case is from 1897, Seaward versus Patterson from the English Court of Chancery, which recognized the general rule that generally only parties are bound to an injunction. However, a non-party can be bound to an injunction and subject to contempt if they have knowledge of the injunction and take acts to essentially obstruct justice or offend the dignity of the courts. Wright and Miller recognized that early American courts adopted this Seaward Framework and issued injunctions, quote, purporting to bind the world. Now, this idea has been subject to scrutiny, but some cases still survive. I would point to United States versus Hall, a 1972 Fifth Circuit case, which would hold a non-party in contempt of an injunction on an obstruction theory. So I anticipate this issue to come up more often. As universal injunctions keep getting granted, you'll have parties try to get creative to avoid their consequences, And so the issue of whether a non-party can be bound by universal injunction will become more frequent, I believe. And finally, my last point, which touches on some of Professor Morley's comments, and I would highly recommend his 2 articles to you. They're great, highly informative, and you heard it today as well in some of his comments, that in his opinion, there should be no universal or defendant-oriented injunctions absent Rule 23b2 class certification. Many people think that the class action device is the solution to the universal injunction problem. But I'll point out that the plain text of Rule 23b2 only speaks in terms of final injunctive relief. Most of these cases, though, are litigated in the preliminary injunction context. You'll have a state or a private party obtain a nationwide preliminary injunction, and then the federal government seeks then to stay that at the Court of Appeals level or stay that at the Supreme Court level. So it's unclear to me whether a class can even be certified for a preliminary injunction. And related to that, many courts assert that they possess the inherent equitable authority to grant injunctive relief to the proposed class prior to class certification. That's reflected in Newberg on class actions, McLaughlin on class actions. I would highlight Washington versus Reno, a 1994 case from the Sixth Circuit, which upheld a national injunction against the Bureau of Prisons, which was issued before class certification. So if it is true that courts have inherent equitable authority to grant injunctive relief to the proposed class prior to class certification, to me that just sort of gives up the game. It indicates that class certification isn't a prerequisite for a court's ability to grant injunctive relief to non-parties, and it really just circles back to my first point that it boils down to a court's inherent equitable authority, which I think under certain rare circumstances they do have. Thank you.
All right, now we're going to have some conversation amongst the panelists. I don't know if you noticed, but Professor Morley was scribbling notes here vigorously. So I have a thought maybe that you would like to go first. Professor Morley.
Sure, thank you very much. In response to Scott's comments, I think you're absolutely right that facial challenges are one of the areas where people are being misled by language, and they're confusing substantive constitutional law doctrine with procedure. Whether you are able to bring a facial challenge, whether your legal arguments amount to a valid facial challenge, is a substantive question of constitutional law. The question of what remedy are you entitled to and what is the scope of the remedy that you are entitled to once a constitutional violation under any theory has been established is instead dictated by Article 3, by equitable principles, and in certain respects by the rules of civil procedure. That in itself, assuming you don't go beyond certain very, very broad boundaries, that in itself is not dictated by substantive constitutional law. When a court holds that a law is facially unconstitutional, it isn't making that ruling in the abstract, right? We've often heard courts aren't roving commissions. When a court says a law is facially unconstitutional, particularly a district court, it's doing so in the context of a particular case among particular litigants, and the legal impact of that ruling is limited to the scope of that case. So it would be inappropriate for the district court to then bootstrap and attempt to give that ruling that it believes the law is facially unconstitutional legal effect for third-party non-litigants, and particularly for people who aren't even within the court's personal jurisdiction, who aren't within the court's geographic jurisdiction, who would have their rights otherwise adjudicated by the law of other circuits. With your discussion of the Texas injunction, I think that that's a perfect example of why, rather than just speaking broadly and categorically of nationwide injunctions, why it exactly makes sense to instead say, no, there are different categories. I'm seeking a plaintiff-oriented injunction. I'm seeking an injunction to defend the rights of Texas. This is relief that Texas needs, and just like in ordinary cases, sometimes the relief has to be nationwide in scope to protect my rights, the focus is on the rights of the plaintiff. You could imagine a different argument saying, well, this policy is unconstitutional, so therefore it should be struck down just because it's unconstitutional. That would be inappropriate. You could imagine a different argument saying, well, there are other states who aren't before the court and their interests would be harmed, and therefore this law should be struck down on a nationwide basis. That type of argument would be inappropriate. But the argument that you're mounting, right, there could be a factual dispute over whether factually you're correct or not, but in terms of the structure of the argument, yes, you're arguing that you were seeking a plaintiff-oriented injunction tailored to enforcing the rights of the plaintiff states before the court, and you weren't trying to assert the rights of third-party non-litigant states, and so yes, I think that the framework would in fact bolster that type of argument. The one final point that you raised that I think is worth emphasizing is one of the drawbacks of these nationwide defendant-oriented injunctions is that a substantial amount of critical constitutional litigation is now being handled in emergency stay practice. That is, these nationwide injunctions are appealed through the circuit court, potentially through en banc courts, up to the Supreme Court. The constitutional rights of people throughout the nation are being flicked on and off like a light switch as stays are granted, stays are dissolved, stays are reimposed. Structurally, this is not the way a legal system is supposed to work. And to the extent that we are now seeing these nationwide orders being regularized, we're forcing the Supreme Court to deal with critical constitutional issues in these emergency postures that are not well suited to them and that gin up unnecessary public debate and public controversy rather than playing more of a tempering and a cooling function. I think Jordan made a lot of really interesting points. I would point out that the historical function of the Bill of Peace is to allow a proceeding to settle an issue, right, to bring peace to an issue. Allowing nationwide defendant-oriented injunctions doesn't do that, because if the government wins, the issue isn't deemed settled. There is no peace. Right holders can continue to bring case after case after case until eventually someone somewhere wins. And so the best modern analog to the Bill of Peace is the class action. I'd also point out that before 1966, we had a vehicle, and somewhat analogous to what Jordan was suggesting, what was called the spurious class action, where members of a putative class could sit back and wait until after a lawsuit was over to see if they won before they decided to jump in and become class members. The whole reason that Rule 23 was overhauled in 1966 and that Rule 23b2 was created was to get rid of the spurious class action and require that if you're giving class-wide relief, you do so in the context of a class action. The final point I'd just like to make is United States versus Mendoza rejects the notion that we want critical constitutional issues decided and adjudicated once and for all in the context of one high-stakes case before a single district judge who was potentially forum-shopped in factual circumstances that might not necessarily be representative, that might be uniquely favorable to the plaintiff. That United States versus Mendoza says, for these important constitutional issues, we want percolation, we want relitigation, we want to hear what different circuits and what different even districts say, and to see how that plays out before allowing the Supreme Court to decide what is the case in which we're going to adjudicate this? What is the factual context in which we're going to adjudicate this? What posture makes the most sense rather than having it forced upon us? The one final thing I'd like to say about the Texas overtime case, the court in that case, the injunction itself, didn't purport to bind non-parties. The injunction itself just said, I'm setting aside this regulation. The employee in New Jersey sued. The only reason this employee the Texas District Court held, the only reason this employee was found to violate the injunction wasn't because it was a nationwide injunction, it was because of how the court was construing Rule 63d2. The court held that by suing under a regulation that the Texas court had set aside, this employee was acting in concert somehow with the Department of Labor. And I would suggest that the main significance of the Texas case isn't so much about nationwide injunctions, but about that is not a proper interpretation of Rule 65D2, and I would suggest we're likely to see the Fifth Circuit overturn that, the notion that if you sue under a regulation that a district court has set aside, that in and of itself means you're acting in concert with the agency that promulgated the regulation. That is a very aggressive interpretation of the rule and not one I would expect to be affirmed.
Mr. Keller?
I want to touch on the class action argument and concept because, and just in playing this out practically, I'm not sure that just kind of pushes the argument off once removed, but you're still going to have all the problems. Because if I understand it correctly, Federal Rule of Civil Procedure 23B2 allows class certification when you're talking about prospective injunctive relief. But in B2 is a mandatory class when it's certified, and you can't opt out of that class, at least if there are no money damages. Well, so now practically think about that. I think I've said that correctly up to this point, right? Okay, good. So say a California court has before it a motion to certify a class on behalf of all 50 states in insert whatever administrative policy you want to. And the court says, yeah, you know, this is a facial challenge. The arguments you're making would apply in all 50 states, so I'm going to certify this mandatory opt-out class. Well, what just happened there? The state of Texas, the state of North Dakota, every state in the union is now hauled before that federal district court in California, mandatorily no opt-out. Is that any different from what we have right now when someone goes to a district court and raises a facial challenge and asks for a nationwide injunction? I'm not sure that it is. Now, there may be some important reasons that you'd want to at least force litigants to possibly go through the steps of having a court certify that, and I suppose there'd be some type of maybe abuse of discretion review on the certification, and class certification is obviously a big issue that the Supreme Court frequently addresses. But if it really is the case that the arguments pressed would render the policy invalid in all 50 states, and they're not seeking money damages, I'm not sure that then it necessarily would be an abuse of discretion for that court to certify that class. So maybe that would just be dotting the I's and crossing the T's, but we're still left with this situation where a single district court is going to be able to block an administrative policy. And so I think if we're arguing about not what's the proper role of courts under rules or what's the proper use of injunctive or equitable power, but instead what we're worried about is should a single district court be able to flip a policy on and off, I think you're still going to have that problem under the class action construct.
And I would just like to pick up where Scott left off as well. I mean, national class actions have many of the same drawbacks as universal injunctions. They stop percolation. Once a national class action is certified, there aren't many litigation for the most part stops. It forces the government and the Solicitor General to appeal at that point if it's against the federal government. And it also puts pressure on the Supreme Court's docket to take that case, given that everything is frozen. The Supreme Court addressed all of these issues in Califano versus Yamasaki and said that even though those are important considerations, it doesn't prevent a nationwide class action from being certified. So there is some tension between Califano on the one hand and U.S. versus Mendoza on the other. There is some tension there that needs to be resolved. But it doesn't necessarily, those objections to me aren't necessarily fatal to a universal injunction. And similarly to Professor Morley's points about some of the criticisms about bills of peace and not settling the rights of others, I mean, people made that same objection to bills of peace in English courts of Chancery as well. Pomeroy documents that in his 1881 treatise, that people objected to bills of peace because they didn't necessarily settle the rights of everybody, that if one of the tenant loses, another tenant could perhaps try again. So that objection has been raised, just like it continues to be raised, and it's still not necessarily fatal. And then with the Department of Labor overtime rule litigation, I think if you look at that order, it did quite clearly purport to bind non-parties. It was quite clearly on a nationwide basis. It was issued on a nationwide basis to stop the rule from going into effect. It was meant to stop the status quo, which at the time was the rule didn't exist. That was the status quo. So the rule, you can't enforce a rule that never actually went into effect in the first place. I do agree that the district court relied on sort of a acting in concert or privity theory, but the states also argued that just under general equitable principles that you can bind a non-party to an injunction if they have knowledge of it and take steps to obstruct justice and offend the dignity of the court.
Professor Morley, I'm sorry, I feel like You need to defend yourself one more time.
No, I mean, I agree with Scott. I think that right now, where we are in terms of courts issuing nationwide defendant-oriented injunctions is the worst of all worlds, for the reasons I articulated. I think one step up from that, at least if we confine this to class actions. You're right. It raised the concerns that Scott raised are entirely correct, and it's even worse than Scott said, because in B2 classes, the members don't even necessarily have to receive notice, and so I think that there are due process issues that arise in the context of binding people to B2 to the results of B2 class actions. I would say that the reason why, at a minimum, moving toward class actions and not allowing nationwide defendant-oriented injunctions in non-class cases offers two benefits. Number one, subject to this due process issue, at least you have symmetric preclusion, that once a class is certified, then if the government wins, those class members are bound by the ruling. If the government loses, all of the class members' rights get enforced. So you have that symmetry, which makes the proceedings more fair, rather than the status quo right now, where it doesn't matter how many plaintiffs lose. If someone eventually wins, then they're able to get a national relief on behalf of all right holders. The other main issue is, in thinking about nationwide plaintiff classes, I argue that, despite Califano, that district courts should limit their classes in constitutional cases to either their district or their circuit, so that a ruling by a single judge in a single case doesn't have national effect, doesn't give rise to the same structural problems as a nationwide defendant-oriented injunction. But Scott's right. The thinking about this in the class action context is still a second-best outcome. What I think would make the most sense in this context is looking beyond injunctions and looking to the other tools that the judiciary has to enforce their rulings. And here I would defend stare decisis, that right now one of the main problems, one of the main reasons why litigants seek this type of broad relief is precisely because if you win in the district court, that ruling has no stare decisis effect. And so we can alleviate many of the concerns about class certification, we can alleviate many of the concerns about asymmetry, if we afforded district court rulings stare decisis effect, and we could debate, should they bind on a district-wide basis, should they bind on a circuit-wide basis, since all the districts within a circuit are all purporting to apply the same body of circuit law. So I would suggest that if we used stare decisis, if we gave district court rulings stare decisis effect, that would, through a more appropriate mechanism, through a way that doesn't defend Article 3, that doesn't defend traditional principles of equity, that would provide a means of enforcing the rights of third-party non-litigants without having all of the problems of defendant-oriented injunctions.
Great. We are going to open it up to questions from the audience. Anybody? Yeah, right here. Please stand. Yeah.
I think we got a microphone coming for you.
Just a quick question for Jordan with regards to the litigation you were discussing on the overtime. Scott made a pretty good distinction between the tailoring of the remedy in the Doppel case versus the Chicago sanctuary case. And I'm not sure I see a distinction between the sanctuary cities case and your case. Particularly, what interest does Nevada or Texas have in whether a particular employee, Chipotle has to pay a particular employee overtime in New Jersey, particularly when by enforcing that contempt decree you took away an economic comparative advantage of your own state in that case. So I'm just curious about that.
I think that one of the justifications relates to one of the other points Scott made about having sort of a uniform system of immigration in that case. Now that's, granted, the distinction there is the Constitution requires that. But here, the Department of Labor itself, when justifying the rule, justified it on having a uniform application across across the country. And so it goes to the point where it's almost like similar to indivisible relief, but not quite, where you have a regulation that applies across the country. So it would have made sense to have sort of a patchwork of the states that didn't join the lawsuit having the overtime rule go into effect there, and whereas it's enjoined in other states when the Department of Labor itself justified the rule on it having nationwide application for economic benefits.
in the back.
I'd be interested in Professor Morley's observations on associational standing and how you think that bears on the question of, can an association obtain relief that uniquely protects all of its members wherever they are? And then how do you distinguish, if you're the agency, between whether you can enforce a regulation because you may not know whether the person you're enforcing against is a member of the association or not?
Great. So there are two issues there: the constitutional issue and then the practical issue. In terms of associational standing, just by way of background, is distinct from organizational standing. With organizational standing, a group goes into court and says, our interests as an entity, our interests as a group are being harmed, and so we are suing in our own name as a group to enforce our own rights. Associational standing is different. Associational standing is a group that comes in and says, our members' rights are being violated. They could come in themselves and sue because it's their rights that are being violated, but the violation also impacts our mission as a group, and so we're acting as a stand-in, that we are coming into court as an association on behalf of our members to enforce the rights of our members, and so in an associational standing case, it's really the members that are the real party in interest. It's the members whose actual rights are at stake, and the group is, in a sense, just a stand-in. And so, number one, descriptively, many associational standing cases, the court will simply give a nationwide defendant-oriented injunction, or more commonly a statewide defendant-oriented injunction at the state level, which raises a variation of the same types of themes that we were talking about, just one step down. But the problem with that is the associational standing is basically just a procedural mechanism. It is essentially a joinder mechanism that, rather than thinking of it as the group, since the group isn't asserting its own rights, technically, the proper way to handle an associational standing case would be, at the end of the case, the association submits the list of members as of that moment in time whose rights are being violated. Those are the real parties in interest. The fact that procedurally we don't make them be named as the litigants don't change the fact that the association's standing is based on and arises from them, and they are the people who are entitled to relief. This then leads to your practical question. Well, okay, if you're a government agency then, how are you possibly supposed to determine what people are or are not protected by this injunction, who you can and can't enforce this regulation against? And I would suggest two answers. Number one, whether or not that is practical will vary on the nature of the case, will vary obviously on the scope of the injunction. But secondly, if an injunction, if a properly tailored injunction raises practical problems, raises logistical or administrative difficulties, the government agency can easily handle that by simply, on its own, choosing to suspend or amend or modify the regulation. It's not for the court to say, here's the order that I am constitutionally entitled to issue, here's the order to which the plaintiffs are entitled, but because I think it's going to be hard for you to obey this, because I think it's going to raise administrative difficulties, because I think it's going to be burdensome or inconvenient, I'm going to make it broader. In cases where you think the defendant is going to try to evade your order, prophylactic relief can be appropriate, but if your main concern is just burdensomeness and administrative hassles, the real way of handling that is simply for the defendant agency to modify or suspend the order on a broader basis, rather than for the court to force it to do so and preclude it from trying to come up with alternatives.
Up here in the front. Yeah, the mic is coming.
Hello. I wanted to point out to the issue of injunctions from separation of powers. Now, Article 3 gives the judiciary the judicial power that extends to all cases in law and equity. Now, if we adhere to the principles or the theory of textualism, that is that's not a power that is limited in any sense. So if you limit any, if you want to put any limits on the power of the judiciary, it will have to take the power from the judiciary and give it to other branches. Now, either it's going to go to Congress, as it was pointed out by Professor Morley, under Rule 26 or class action, or you give it to the executive branch as, you know, allowing them to take action in states that the injunction does not apply because the injunction got limited. So my question would be, should the judiciary be weakened in that sense that it shall not have the power to issue nationwide injunctions? And they're called nationwide, but it is just the court's power, and the court's power is nationwide. It is not something new, I believe.
Is that directed to Professor Morley?
That would be Robert.
Okay.
Well, again, I agree with you. The court's power is nationwide, and I think I'm echoing what Scott here said. The main concern isn't the geographic scope of the injunction, and that's the main reason I think it's terrible to talk about it in terms of nationwide injunctions, because it misdirects our focus. Our focus shouldn't be geography. Our focus should be, what is the injunction tailored to do? Are you trying to enforce the rights of the plaintiffs before the court? And a plaintiff-oriented injunction, which sometimes might have to be nationwide in scope, and that's fine. Or are you trying to enforce the rights of third-party non-litigants who aren't before the court, who might not even necessarily live in the court's geographic jurisdiction, who might not even be subject to the court's personal jurisdiction, and Article 3's case or controversy limitations, as the Supreme Court has interpreted them, and we can have a separate debate over whether that's originalist or textualist or just made up, but at least we're going Lujan, the body of law arising from Lujan, City of Lions, the court has held a plaintiff doesn't have standing to assert the rights of third-party non-litigants not before the court. Granting relief in their favor simply is beyond the scope of that Article 3 case or controversy.
Anybody else? Okay. Right here.
Yeah, I have a question for Scott.
Yeah, because we can't, the further you get away, we can't.
Sure.
see.
So just practically, you mentioned with the sanctuary city law, Chicago ran into federal court, gets a nationwide injunction. Why wouldn't the state of Texas run into the Eastern District of Texas, seek declaratory relief that the same sanctuary city policy was constitutional on the basis of, we have this state law, we don't do sanctuary cities? Wouldn't that give lie to the idea of a nationwide injunction if one district court says one thing and another says something else, and the federal government could say, we're just going to sit this one out until, you know, it percolates up high enough?
The short version is you probably can't do that because of a Supreme Court precedent on the Declaratory Judgment Act, and that it usually has to be that a party who would have that enforced against them comes and brings a pre-enforcement challenge, as opposed to, you'd almost like flip it twice, that the party that wants it enforced and actually here wouldn't even have the enforcement power could do that. So the short version is because of the way the Declaratory Judgment Act operates. But could you imagine that if not only were we having nationwide injunctions, but we had every state rushing to their own courts asking for a declaratory judgment over that? I mean, wow, you want to talk about, if you think we have a morass now, that would just open up a can of worms that I'm not sure anybody wants to go down.
We're sort of seeing that, though, in the Doppel litigation. We have the nationwide injunction out of the Fifth Circuit. We now have the Second Circuit hearing oral arguments about whether or not it really is bound by that injunction and whether or not that was proper. So, the reason why that lawsuit at least could get off the ground was because there was adverseness there, that you had the opposing litigants taking different positions on whether the injunction was binding in good law. In the hypothetical, both Texas and the federal government would both be saying, yes, the ban on sanctuary city funding is valid, and so another obstacle, even beyond the DJA, is the lack of adverseness.
Here in the front.
I guess I have two questions that are unrelated. One is there anything that we can learn from nationwide injunctions issued in the IP context, in trademark or copyright or a patent? And I do note that in the patent context, we have one court, one federal circuit court that hears those appeals nationally. So it might dovetail a little bit with your discussion on the DC Circuit in the regulatory context. And then the second question I had was, the Ninth Circuit last month issued a decision in the contraceptives case. I don't know if any of you followed that decision, but what was interesting there was a panel, it was a divided panel, and Judge Wallace in the Ninth Circuit, I think, wrote that decision, and what he said was that we have to limit this, what was a nationwide injunction issued by the district judge, limit it to where the plaintiffs were. And I think it was California, which is in the Ninth Circuit, still in the Ninth Circuit, and 4 other states that were not in the Ninth Circuit. I think New Jersey, Delaware, maybe New York, and I can't remember. But I think 4 that were not in the circuit. I don't know much about the case. I remember reading it and thinking, gosh, maybe this panel would know something more and have a comment on what the Ninth Circuit did there.
I'm not that familiar with that case. I'm not necessarily familiar with that case. I could be thinking of a different one. But I know there was recently a nationwide injunction that was narrowed, I think on the grounds that there was lacking evidence of injury to some of the other states. And so it limited the injunction to the states that had proven injury based upon evidence. I don't know if it was affidavits or in what form that took. But I'm aware of one recently, and I'm not sure if it's the same one where it was narrowed. That's the one. Yeah, so I think, that somewhat makes sense if they hadn't proven that they were actually injured. I guess I could see where that would make sense. But that's the extent of my knowledge of that one.
But briefly, to your point, that's not to say that if you're a state as a plaintiff that you necessarily have to sue in your state or even in your circuit. And we see coalitions of states bringing lawsuits outside of their circuit and obviously outside of their states all the time.
To go back to the first part of your question, what can we learn from IP nationwide injunctions? So that is a perfect example of plaintiff-oriented injunctions, right? If you are a patent holder, you own intellectual property, a trademark, a copyright. If you do business on a nationwide basis, if a competitor is threatening to sell or is selling an infringing product on a nationwide basis, there's no problem with you going into court and getting a nationwide injunction. Again, the part of the confusion stems from the terminology. You would be seeking a plaintiff-oriented injunction. Your rights are being violated on a national basis. The challenged conduct is illegal on a national basis. The defendant is engaging in violations on a national basis. So yes, the relief necessary to enforce your rights would be geographically nationwide. Contrast that with, imagine Apple goes into court and Apple says our patents are being violated or our copyrights are being violated, but we don't want you to enter an injunction just prohibiting the defendant from violating our patents. We want you to enter in an injunction prohibiting the defendant from violating Samsung's patents and other companies' patents, Hewlett-Packard's patents. That wouldn't even get off the ground. Clearly, they don't have Article III standing to assert the rights of other companies. So even though, yes, they can assert geographically nationwide relief that is tailored to enforcing their own rights, they don't have the right to assert the rights of third-party non-litigant plaintiffs and to ask the court to expand the scope of its ruling to protect third parties not before the court. And those same principles apply in the context of constitutional cases. A plaintiff can say, stop the government from violating my rights. The plaintiff can't say, oh, and by the way, stop the government from violating Scott's rights or Jordan's rights.
Anybody else? Here.
I was wondering if any of you guys have comments about the any congressional responses to these universal injunctions. I know that Judge Costa wrote something about potential 3-judge panels deciding these nationwide injunction cases, sort of like redistricting cases. I still probably see some constitutional issues with those too, but I was seeing if there was any comments on those.
Yeah, no, Judge Costa's proposal would be to constitute a 3-judge panel with a direct appeal to the Supreme Court in very similar context to the election redistricting context that still exists today. Now, obviously, there used to be, that used to occur a lot more, and Congress had allowed that in various contexts. And up here, as we were talking about the class action context, it strikes me that, if Congress wanted to think of something to do here, I mean, if you had one of these 23B2 mandatory non-opt-out classes and you were raising a facial challenge and the injunction would apply nationwide, maybe that would be a scenario where if that's what you're raising, maybe it should go to a 3-judge panel with a direct appeal to the Supreme Court. I mean, practically, the Supreme Court's going to see these in stay motions anyway. So, yeah, that might be one way to manage the system better. Of course, even then, you are still going to have the problem, at least it's not one single district judge, but it's going to be a 3-judge district court in one district court that would be then setting the policy. But I guess if you're going to have the class action mechanism there anyway, and maybe that's better.
Up here.
I have a couple of comments. First, Mr. Keller, the 23B2, you say mandatory non-opt-out class action, but the plaintiff would still have to satisfy 23A, which requires showing of typicality and adequacy of representation. It would seem to me that it would be very unlikely that a court would certify a nationwide class of all states. So California would be representing everyone because sovereign immunity would seemingly preclude typicality or adequacy of representation if someone objected. So it seems to me that the class action methodology might work well for a check on nationwide classes. And then, Jordan, you mentioned preliminary injunctions, and of course that's true. You can get a preliminary injunction, but a lot of these cases that are being brought, they're not bringing a class action. They're just bringing an individual action, and they're seeking a preliminary injunction. It seems to me that that argument only works if the plaintiff has filed a class action, is seeking a class action, and the court's granting preliminary injunction to preserve their own jurisdiction to award final relief. And then my only final comment is, Professor Morley, your suggestion that the district courts could have stare decisis effect, I can't believe is serious, because stare decisis applies hierarchically, right? You can't have stare decisis. You can have collateral estoppel, but stare decisis among courts on the same level, I can only shudder to think about if we had it at the circuit level and the Ninth Circuit was going to be stare decisis and binding on all the other circuits. So I don't know if you intended that seriously. So I throw this out there to all the panelists just to be a naysayer, I guess.
Well, my first reaction is, who the heck knows what California courts are going to do?
If I could respond, so there are two types of stare decisis. There's horizontal stare decisis, which is what you're referring to, which is the concept of a superior court's rulings being binding on inferior courts. And then there's the concept of vertical stare decisis, which is a court's rulings being binding on courts of that same level. So for example, the Supreme Court, in a sense, has vertical stare decisis to the extent that it defers to, or it gives way to its previous judgments on an issue. We see vertical stare decisis at the circuit court level. Most circuits call it the prior panel rule, where a 3-judge panel of a circuit court is bound as a matter of horizontal stare decisis by what earlier panels have ruled on that issue. So that's the reason why circuit law or why circuit court rulings are binding at the panel level, and you have to go to the en banc circuit court in order to, if you want to reverse or overturn a circuit court ruling. And then at the level of the district court, there was an article in the Nevada Law Journal by a law professor, Joseph Mead, that suggested that around the 1950s, district courts actually did have at least a presumption of stare decisis where they regarded their own rulings as binding on each other. So I'm certainly not suggesting inter-circuit stare decisis. I'm not suggesting nationwide inter-district stare decisis, but within a circuit, we already have intra-circuit stare decisis through the prior panel rule, and so I would suggest we can have either intra-district or intra-circuit vertical stare, or excuse me, horizontal stare decisis from district court rulings.
And just to clarify my comments, I recognize that these cases aren't generally filed as class actions, and that was a little bit my point, is that they're not filed as class actions, and people offer the class action device as the solution, but I'm not sure class certification is even available for a preliminary injunction. That was the point I was trying to make.
Okay, on that note, it is now 10:30, and I would like to ask you to join me in thanking our panel for this terrific presentation.